Welcome to CivilNet. My guest today from Worcester, Massachusetts is Professor Taner Akcam, who is at Clark University, holds the Genocide Studies chair there, and of course is the historian, perhaps the first Turkish historian who is popularly recognized as not just talking about the genocide as fact, but also about all of the various folds, the causes, the consequences, and looking at all of that from the perspective of the Turkish citizen, the Turkish historian, the Turkish state. Taner, thank you for joining us again on CivilNet.
Oh, nice to meet you again. Good morning. Oh, good afternoon to you.
Good afternoon, good evening. This is, it's a 24-hour world already, so it doesn't matter. Taner, it's going to be impossible not to ask you about Turkey's domestic situation these days, but I will restrain myself and instead ask you about something that possibly is more consequential, and that is the decision of the European Court of Human Rights in the case of Perincek versus Switzerland, where Perincek, a Turkish citizen, was charged with and found guilty of breaking the Swiss law on denial of the genocide, and 3 levels of Swiss courts found him guilty, and the European Court of Human Rights overturned that, but not on the freedom of speech issue. Is that right?
No, I mean, on the freedom of speech issue, with the argument that denial of Armenian genocide cannot be a part of freedom of speech. I mean, better to...
Cannot be covered by that, yeah, protected by it.
Because genocide in case of Armenians is not an established fact. There is no a court decision determined by an international court, and it has not been acknowledged by the world community. And another important argument of the court is that there are, let's say, around 90 countries acknowledge the Armenian genocide, but in none of these countries there is a law ban the denial of Armenian genocide. Even these countries acknowledge the Armenian genocide as a fact, they don't see the necessity to ban the denial of the genocide. So overall, the European Human Rights Court's decision is not itself on itself is not very important. I mean, you can really argue whether or not genocide denial in Europe can be restricted within the freedom of speech. This is a debate for itself. The problem of the court decision is the justification, how court justifies its own decision. And courts really takes here Turkish government's denialist argument. This is the problem, and make serious legal mistakes by making this decision. I mean, the first important decision is making a categorical distinction between Holocaust and Armenian genocide. So we have to know that in banning the Holocaust denial in Europe, genocide is not a legal problem. In Europe, denial of Holocaust is banned because there is an international court decision, and this determines Holocaust as a crime against humanity. This is the important part. So legally, in Europe, it doesn't make big difference between genocide and crime against humanity. And if you look legally, the cases of Holocaust and Armenian genocide, there is no important distinction between Holocaust and Armenian genocide. In both cases, we have international body, international institution established the case as crime against humanity in case of Armenian genocide and in case of Holocaust. So there is no legal difference between them.
So why did the court choose to make that distinction?
Exactly. This is a legal mistake that the court makes. Look, the crime against humanity was established in case of Armenian genocide 1915. Crime against humanity established as a crime category by an international body in Paris Peace Conference. There was a subcommittee to determine the crimes and to establish an international court. And this commission also established the crime category as crime against humanity in case of Armenians. And this both crime decision, this both decision, 1915 and 1919, was taken by Nuremberg and made a law. And this is the London Agreement, and then this is the basis of the Nuremberg Tribunal. So, as you see, the only difference between Armenian genocide and Holocaust, it achieved the level of an international court in case of Holocaust, but in case of Armenian genocide, it was part of an international agreement. It was the Article 300 of Sevres Agreement, but it didn't achieve the court level because of the political development, as we know. So legally, there is no distinction between both.
So why and how is it that you can recite this and say, look, this is the legal basis for recognizing the genocide as a crime against humanity, and the defendant in this case wasn't able to do that? The defendant, the Swiss government.
There are different explanations. I mean, if you ask me, this is the white man's supremacy. European court really make it very clear with its justification that they categorically distinguish Holocaust from other big mass atrocities.
So now,
this was the case in social science in 1970s, 80s also. Uniqueness and unprecedented character of Holocaust. This is what they believe.
Except that we thought that 40 years later we'd pass that. So now what must happen by March 17th? This verdict was December 17th by European court regulations. If there is to be an appeal, it must be within 90 days. That's March 17th. So what should happen?
Swiss government apply to the appeal court. I don't know which camera it is. I heard that there are different cameras they don't have an appeal camera in European Human Rights Court. What I learned from the legal scholar, there is another camera responsible for these appeal cases, and Swiss government should decide to go to appeal.
And towards that end, there have been several sets of appeals to the Swiss government. Turkish human rights community, the International Association of Genocide Scholars. Is this going to be enough to move the Swiss government?
I don't think so. They have their own criteria and they will decide accordingly. I hope our letters and our appeal to the government will find an echo there. Let's hope this. I don't know.
And there's probably no doubt that if this verdict stands, that the Turkish government or the denial community will certainly utilize it.
Oh, definitely. They started to utilizing it. Maybe you heard in California, for example, recently there was a law passed through the Californian Senate where the Californian state decided to teach on Armenian genocide and especially the oral history records, to use these oral history records in their curriculums. And then Turkish lobbying group, based on this Swiss government's decision, organized a huge campaign, and they are doing in the United States, and it will really disseminate throughout the world.
I'm going to ask you about the domestic situation in Turkey, but from coming through a different window. Part of the problem now in Turkey is not just the corruption cases that have come to the surface, but the tension, the struggle between Erdogan and the Akcam party and those who support Gülen, the Gülen movement and so forth. And the institutional allegiances are coming to the forefront and there is a tension. Is this tension going to be useful for those of us who would like to see justice in the Hrant Dink case, for example, and looking at it from our small, narrow window? Is this tension going to be helping us or hurting us?
There is a German way of yayin. I mean, it is yes and no. Both cases, it's not a one-way street. Definitely, at least for the Gülen circle, I can affirm, this is my impression from the group, that they are moving more to democratic positions in other areas of the human life. In freedom of speech and facing history, they are now more in Kurdish issue, they are more sensitive than before. But this fight now at this moment it is now beyond Gülen AKP conflict. Gülen is not, I mean, they are an important part of this conflict at this moment, but where we stay at this moment, it is far beyond it, because it is so obvious now we have a theft on the government. He's a thief. I mean, it's so obvious, and there is a system there also. He established a system of thievery, and this is a problem between prime minister and the entire society, not Gülen people. You can compare maybe with Ukraine, Turkey at this moment.
Does it matter that I'm trying not to use the word thievery, the accumulation of funds that have been alleged, that have been demonstrated through pictures and other ways, does it matter that they are saying that funds such as they are have really been used for the party and the party's work and not necessarily to enrich individual politicians? Does that matter?
Yes, and it is, I think, very crucial, and this is the point where we say that the corruption is the system itself. Look how they organize the entire corruption. In previous cases, before this government, it was the individual who were corrupted, who took the money for their individual purposes. What they did here is they even, maybe you have heard about it, they even got a fatwa from an Islamic intellectual. And the fatwa is whether or not it is legitimate or eligible in Islam that government take funds or donations from the companies who really participate in government bids and took these contracts that they pay voluntarily for certain charities. And the fatwa said, yes, you can take this money. And this is how they institutionalize taking money from companies for certain charities. Now, this is the problem here. If a company pays to charities certain amount of money, donates, this is their expenses. They put their expenses and they reduce this from their taxes. This means their expenses is high and state, they pay less taxes to state. So this means the entire corruption actually is paid by the taxpayers. The entire Turks today paying the corrupt system today. This makes the system is a big problem, and this is why they are so panicked at this moment, because it's not the individuals. This is the reason why they really rallying around Erdogan, because they all part of this corruption. This is the system. This is the change in Turkey, and this makes the issue more dramatic and important.
Of course, we will continue to talk about this. I can only say that it is amazing watching it, and especially the visibility, the high level of visibility around this issue.
It's correct. I mean, this is unfortunately the historic character of Turkey. Turkish people don't go much on the streets compared to Ukraine, compared to Armenia, maybe. In all other states, you have this civil courage. People run in the street, and unfortunately, we are very reluctant as society.
Well, that's not what Gezi Park demonstrated, so perhaps that's changing too.
Let's hope. Gezi was indeed, in that sense, a change in Turkish history.
Taner Akcam, thank you. We are always pleased to talk to you about continuing changes in Turkish history.
Thank you very much.
Thank you.
Good.
We've been talking to Taner Akcam, historian at Clark University in Massachusetts, both about the Perincek Switzerland decision by the European Court of Human Rights, as well as ongoing turmoil in Turkey and Turkish politics. Thank you for following us on CivilNet.